Ladies and gentlemen, welcome back to Gambling Savant. This is the second update of today regarding the SEC's amended complaint versus Ripple. Jeremy Hogan, with Legal Briefs, is going to give you the rundown here shortly in this video clip. Make note, they bring up the term scienter, which means knowledge of intent. So, the original complaint was against Ripple as a company. This amended complaint has new allegations against Larson and Garlinghouse. In paragraph 110, it states that both Larson and Garlinghouse played a significant role in negotiating and approving Ripple's institutional sales and other offers and sales of XRP to institutional investors, including while Garlinghouse was COO. So this is the cat and mouse deal. The SEC knew that Ripple was going to provide motion to dismiss. So in turn, the SEC decided to file an amended complaint to kind of throw them off or block their motion. So now the SEC has targeted Larson and Garlinghouse personally. So let's take a look here. It's an interesting clip.
So, for example, the SEC added to the amended complaint paragraph 110, which says, quote, Larson and Garlinghouse both played significant roles in negotiating and approving Ripple's institutional sales and other offers and sales of XRP to institutional investors, close quote. So that is a new allegation that is pretty typical of the new complaint. This amended complaint was kind of heralded by the letter to the judge last week, where the parties told the judge what contemplated motions were out there. That's in, I think, subparagraph 2 of the letter. In short, what happened was that the lawyers for Garlinghouse and Larson told the SEC that they were going to file motions to dismiss the lawsuit against them, and the SEC said, well, okay, then, if you're going to file a motion to dismiss, we're going to go ahead and amend the lawsuit in order to try to avoid your motion to dismiss, and therefore they got the amended complaint done, and they put in a lot more facts showing how Garlinghouse and Larson were personally involved. I still think there will be a motion to dismiss, but I think the individuals will probably lose those motions because I think there's enough facts now in the lawsuit to keep them in the litigation. And that's bad for Ripple because Garlinghouse and Larson are obviously high up in Ripple and will decide what Ripple does. And until you've been sued by the federal government, you have no idea how stressful it is. I mean, it's the kind of stress that leads to sleepless nights, tears. You can't concentrate. You can't enjoy time with your kids. It's horrible to be on the end of this kind of lawsuit. And it's going to affect what Ripple does because Brad and Chris are obviously high up in the Ripple hierarchy. So we hope they get out, but I don't think they will. I think the SEC has kind of locked them in now. But I wanted to do some quick conjecture about why they were sued to begin with when no other individuals have ever been sued by the SEC in a crypto lawsuit. This is the interesting stuff for me. I think there are three possibilities here. First, the obvious answer is because they kept such a large amount of XRP for themselves that the SEC wants to kind of recoup or disgorge those large amounts of profits. The second possibility is that the SEC wanted to put that stress on Brad and Chris to help the case against Ripple. And this is common in federal criminal prosecutions where you'll see that they go after your friends or your family in order to put pressure on you. Or maybe possibility 3, which is the most subtle, is that the SEC is devising an escape from this lawsuit for itself, one in which it can punish the owners, founders of the company, and let the company itself off the hook. Now, I wouldn't have thought this except for how long the SEC let this case go before filing the lawsuit. In this situation where you have to where you've let it go on for 8 or 9 years before filing a lawsuit, it might be the most equitable resolution to punish the owners in the pocketbook while allowing the company itself to settle out and continue business. It makes sense to me, enforcing the law as to wrongdoers while not punishing individuals who bought the coins. Option 3 is the closest to a win-win for the SEC that it can get if it truly wants to enforce the law and protect purchasers of XRP, and it can't do it if it hadn't sued Garlinghouse and Larson. But that's all conjecture for now. But there is one more really important thing that was added to the amended complaint, and it's not obvious, but it is super important because Ripple is teeing up a jurisdiction argument. I could smell it, and the SEC does also. This was hard to catch, but look at paragraph 186 in the amended complaint, which is new, and it says, quote, Garlinghouse offered and sold XRP on at least 2 platforms incorporated in the United States and 1 incorporated abroad with its principal place of business in New York. Now, why was that added? Because a court must have jurisdiction over the matters in the lawsuit. For example, if you go to Amsterdam and you smoke some stuff over there in Amsterdam, a court in New York has no jurisdiction over you for that because you were not smoking it in the USA. You can't get in trouble for it unless you get in trouble for it in Amsterdam. But with the sales of a cryptocurrency, specifically XRP, where you have a sale and transfer of a digital asset made and logged on perhaps hundreds or thousands of nodes around the world, how are you going to prove jurisdiction over that transaction? How are you going to prove that the actual transfer occurred in the USA and that the court has jurisdiction? That simple question shows you how antiquated our legal system is when it comes to digital transactions. The courts have only recently even attempted to address that issue in the SEC versus Traffic Monsoon case, but without going into too much detail because it'll bore you to death, suffice it to say the case law is a mess, and it does open up the door for Ripple to tell the court that certain transactions may have had enough effect in America that there is jurisdiction, but other transactions didn't, and the court can't do anything with those because they were not American related enough. If Ripple wants, it can make a mess of this jurisdiction issue, and the SEC's amended complaint kind of clued me in on it, and also clued me in that they're worried about it. But enough for one night. Thanks for watching.
All right, everybody. Well, Jeremy does always a beautiful job of, breaking down the information and allowing the viewers to easily make sense of what's at stake and what the updates are here. So, in a nutshell, the SEC has targeted directly Larson and Garlinghouse. And make note, the last portion of that video clip, how is the SEC going to prove jurisdiction on these sales of XRP? That was added to the complaint. It's the focal point, in my opinion, of the updated, amended complaint. So, what do you do with non-American related transactions? How do you prove it? How do you sort through them? How do you calculate the figures? Time will tell. That's where we stand. And I will certainly keep you posted on the latest information that breaks from this. If you like this content, please like, share, and subscribe. And I'd love to chat with you in the comments. I'm going to leave you with a quote from Robert Collier. He says, "Success is the sum of small efforts, repeated day in and day out." That is all. Take care, everybody. Have a great night, and I'll be in touch with you shortly.